to see is that the public inquiry is not just limited to what happened in the Barbarossa case, but takes into account the whole range of the British military movements, the British military activities in all southeastern Iraq during the whole of the occupation period, So what I've sort of just described does amount to war crimes. There's no single binding definition of what is a war crime, but the most recent one and the most thorough one is located in Article 8, subsection 2 of the Rome Statute of the International Criminal Court, 1998. Under that statute, war crimes include willful killing, torture or inhuman treatment, willfully causing great suffering or serious injury to body or health. It also includes committing outrages on personal dignity, in particular humiliating and degrading treatment, as well as committing sexual violence. But it is clear that the UK forces have been responsible for these crimes. It isn't just the Americans that are involved here, and that's something which we need to be fully aware of. But these sorts of crimes have been committed before in previous military campaigns by the British, or certainly they've been accused of that, say in Kenya and Malaya. So why is there a particular focus this time around in Iraq? And the reason for that is the Human Rights Act. Following the case of Halsgani, which I mentioned previously, the House of Lords said that the Human Rights Act, which incorporates the European Convention of Human Rights into British law, into English law, the Human Rights Act applies to British forces in places of detention where they are holding individuals in detention facilities in Iraq. And if you think about it, it makes logical sense for this result to appear, because if you think of it, in the UK you have police who are responsible for prisoners in police cells, and if they engage in any unlawful activity, they will be responsible for that. So why should it be the case that other agents of the state who have responsibility of individuals have control over individuals in their own secure facility? Why should it be the case that they should escape human rights scrutiny simply because they're in a different country? So I think that was clearly the right decision. And this allows, for the first time, lawyers to take advantage of the procedural elements of the European Convention of Human Rights. Article 2, which is the right not to be killed, Article 3, the right not to be tortured. In addition to the what you could call negative duties, the right of thou must not kill, thou must not torture, there emanates a set of procedural duties such that an investigation, an independent and effective investigation, should occur whenever a state may have committed a breach of these articles. And previously, this wasn't the case at all. Previously, human rights law didn't have a particularly large role to play in armed conflict. It was mainly the international humanitarian law, the laws of armed conflict, which applied. And it's quite clear that the enforcement and accountability mechanisms under international humanitarian law are inadequate. The Geneva Conventions, they do oblige the imposition of effective penal sanctions where individuals have committed a serious breach or grave breach of the conventions, of the Geneva Conventions. And they're required to bring to trial individuals who are alleged to have committed these crimes or who have ordered to be committed these grave breaches. That's in Article 49 of the First Geneva Convention. But as I mentioned, the Baha Mousa case demonstrates that the Army's own accountability mechanism is defective. At the court-martial, only one soldier was found guilty of any crimes. He was found guilty of inhuman treatment, and he admitted to that at the outset. In the Osnabrück court-martial, where the individuals who were involved in the Camp Breadbasket case, and the Camp Breadbasket incidents, where they were subjected to a court-martial, none of them was charged with torture. Despite a submission by the human rights NGO Redress to the Joint Committee on Human Rights, saying that the activities of the individuals at Camp Breadbasket fall squarely within the definition of torture under the Criminal Justice Act. So those are the main sort of issues legally. Other parts other areas we're talking about is perhaps expanding the decision on Halsgani to include the use of human rights not just in detention facilities, but say in a military vehicle. So say that individuals in Kamash, the private house last year that was invaded, and individuals, they were placed into a vehicle, and on the way to the facility at Basra Airport, they were beaten with rifle butts and an old man, a 50-year-old man, he was beaten until blood was gushing from his head. At the moment, the courts haven't decided, or the courts haven't said that in this situation the Human Rights Act should apply. So when we get into the detention facility, that our scaling sort of kicks in. And so one of the areas which we're looking at is to try to expand that. And again, I don't think it's a logical expansion, and hopefully the courts will take that decision in the cases which we're sort of bringing. And also another sort of big area is the actual, where there is a difference between the two legal norms. You have international humanitarian law, law of armed conflict, and you have international law of human rights. And so the question is, where exactly does one start, where does one begin? And it's a very complicated issue. There aren't any sort of easy answers, not only for the court, but also for the individuals on the ground. So that's an area which we're sort of working on, and hopefully there'll be some further clarification there. What certainly I would suggest is that whichever branch of law gives the most protection to an individual, perhaps that should be the one which is used. But again, applying that for a soldier is a bit difficult for him to say, oh, in this situation I should use humanitarian law, in this situation I should use human rights law. So it's complicated. It's not an easy sort of area of law, but hopefully that will be, there'll be some answers in the future. So just finally, to finish, in terms of areas of reform, I think that there needs to be a change of culture in the British Army. I know that perhaps in the public eye, or certainly previously, we were seen as almost like the good guys to the Americans, as was sort of suggested before. But given all the cases which have occurred, that certainly isn't the case. And if individuals believe that they can get away with it, then that sort of precept should be changed. And also, I think the training of soldiers in terms of dealing with a period of occupation where they will be responsible for prisoners, that needs to be improved. In the Aiken report, which was a report commissioned by the MOD covering the activities of the British Army in Iraq, they said that a common theme running through that was that there was just insufficient time to train people. The decision to go to war was taken quite quickly. And in terms of dealing with any potential occupation or treatment of prisoners afterwards, was really sort of left to one side, or it wasn't really examined sort of properly. And so certainly that would need to be changed. That training needs to go in right now, and